The Law Offices of Brian J. Smith.
The question often comes up whether it is easier to simply plead no contest or even guilty to OVI charges. When you are charged with an OVI during your first court hearing called an arraignment, you will be asked to enter a plea. This decision that you have to make is a critical one. The short answer is the right thing to do is enter a not guilty plea. Anything else is simply a bad decision. You have rights that protect you, and pleading no contest or not guilty does little more than give away all of those rights. A not guilty plea, however, will allow you to challenge the charge or at least meet with the prosecutor and try to resolve the charge. Let's look at the difference between a no contest plea and a guilty plea. As far as your criminal charges, there simply is no difference. Both will result in a conviction, both put you at the mercy of the court with respect to what penalty you will get, and both will remain on your record. The difference between a no contest plea and a guilty plea only comes into play with respect to other court proceedings. For example, if you were involved in an auto accident and were sued, the other party could not use your no contest plea as an admission of fault. So, while a no contest plea is better than a guilty plea, the two are essentially the same as far as your criminal OVI case goes. That's why a no contest plea is not a compromise, and you are much better protected with a not guilty plea. The police have rules and procedures that they have to follow. If you plead guilty, you give up any chance of evaluating whether the police did everything they were supposed to, the way they were supposed to, and when they were supposed to. Pleading guilty automatically lets the police off the hook, even if they botched something up completely. Pleading guilty or no contest also eliminates the possibility of pleading down the OVI. Even if the police were absolutely perfect, the prosecutor may still be willing to offer you a plea to a reduced charge. This often depends on factors such as your prior OVI history, whether you cooperated with the police, the strength of their case, and whether you're represented by an aggressive OVI defense attorney. If you plead guilty or no contest, you simply lose the opportunity to seek out a reduced charge. There are also a range of penalties for an OVI. For example, jail time for a first offense ranges from 3 days to 6 months. If you go to the arraignment and plead guilty or no contest, you will have no idea at that time what the judge will sentence you to. You will have lost the opportunity to meet with the prosecutor and perhaps get a sense, if not an agreement, as to what the penalty will be. Always plead not guilty, even if you are making the terrible mistake of trying to represent yourself. A not guilty plea will allow the court to schedule a pretrial, which is a meeting with the prosecutor. That will allow the opportunity to argue your case from the police officer's conduct to mitigating factors and what the penalty will be. If you have an experienced OVI attorney representing you, it is highly likely that you will end up much better than you would have with a blind guilty or no contest plea.
The attorneys at Smith's Law Offices provide personalized representation, valued for their experience and respected for their skills. If you live on the northern coast of Ohio and find yourself in need of an attorney, contact us for a free telephone consultation at 800-641-1970.